All right, sir, you're Joshua Mays, and Mr. Mays is on probation for burglary of a habitation, was placed on a deferred probation back in September of 2021, and that was a 10-year, no, it wasn't, it was a 3-year deferred probation. There was a motion to adjudicate filed. We were here before. Mr. Mays pled true to failure to report and a failure to pay court-assessed fees. Let's see, hold on a second, let me go back and find what the other counts were. So it looks like, do you want to put on any evidence with regard to counts 2 and 3, the education program and the MRT?
Yes, I do, Your Honor.
All right, you can call your first witness, Mr. Nichols.
You swear on me?
Yes, would you please raise your right hand, ma'am? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you.
Ms. Joseph, how long have you been supervising Mr. Mays?
Since April of 2022.
And during that time, was he ordered to participate in the GED program?
Yes, sir.
Has he completed that?
No, sir.
Did he provide you the verification that he was participating in that?
No, sir.
Are you aware of the issue he outlined in the letter to the court that he claimed he made progress while at ISF, but those credits wouldn't be accepted by the program? Or do you know what that issue is?
I read it in his letter.
Do you know anything else about that, whether or not they would take those credits or not?
No, sir.
Okay. But did he give you the verification that he's been participating in that GED program? Okay. And moving on, was he also ordered to participate in the moral recognition therapy program?
Yes, sir.
And has he participated in that?
No, sir.
What level of participation has he done in the MRT program?
He has not even begun to start it. However, while we were waiting to come to court for this, they have since discontinued for a period of time until they can hire someone to offer the class. And we will again, but it's just worthwhile to note that while we were waiting, somebody retired, and so they had to hire someone else to
At what point did they suspend the MRT program?
March of this year,
Okay.
March or April.
But during the years he's been on probation, he had not made
Prior
any
to
progress?
that, no, sir.
Okay. And so should he be, that program you believe will be available in the future?
It will.
Is there anything else contained in your pre-sentence investigation that you want to bring to the court's attention?
Stated what I needed to say.
Okay, thank you. Now I'll pass the witness, Your Honor.
Thank you, ma'am. Mr. Kimler?
Have you checked with the ISF facility to see if they have a GED program, or
They for a fact do, sir.
did you check to see if he participated in it? Did you check to see if he participated in it?
He didn't mention anything about it until after his release from the facility.
And my question is, did you try to
No, I
check?
didn't have a reason to, Mr. Kimber. He didn't say that he had participated in that until after his release.
No, I'm not trying to put you in a defensive posture. I'm just wondering if there's been any kind of independent attempt by the probation department to corroborate what he said about participating in the program while at ISF.
He didn't present any documentation.
So my
And I
question-
didn't check with ISF to verify what he said.
But just to be clear, ISF does in fact have a GED program?
They do.
Okay. Has he maintained employment while he's been on probation?
He has.
So lack of a GED, and again, the GED's worthwhile on its own merits, but it doesn't seem to have impacted his ability to maintain employment, the lack of the GED. He's been able to maintain employment without a
Yes.
GED. So you would say he has worked faithfully at suitable employment?
He has.
What is the moral recognition class? Is that how you say it, recognition?
Yes, sir. That's how you say it.
How many sessions is that?
8.
Over a week, once a week, or once a month?
They present one lesson each week until they have finished the course.
And it's a progression, then they're different classes, it's like a progression 1 through 8.
There
So you
is
would
a
have to-
book that they have to purchase, and they do each chapter in the book until they have completed the book.
In sequence, right?
Yes,
In
sir.
sequence. So he would need at least 8 weeks to complete that if you took one session per week, is that right?
Yes, sir.
Has he maintained proper demeanor with you?
Yes, sir.
And as far as his reporting, he certainly hasn't become an absconder, is that right?
He's been an
has
absconder 3
worked
times.
Well, as far as what she's concerned, has he maintained contact with you, or has he become an
Since his
absconder?
release from custody, yes.
He's maintained contact
Yes.
with you and reported this directly.
Yes.
In your report, you seem to indicate a willingness, a reluctant willingness perhaps, to have him continued on probation. Would you agree with that?
I hesitated to recommend that he be continued.
Did you recommend that or not?
My statement was that I hesitate to recommend, should the court decide. So I'm really leaving it up to the court, because I don't want to make a recommendation.
Because you don't have a recommendation then. So you're not recommending that he be revoked, but you're not recommending that he be continued. Is that fair?
Yes.
But if the court were to see fit to continue him, then you would suggest extending him a year to give him an opportunity to complete the GED, pay his fees, and I guess at this point, once you all get somebody hired to do the moral recognition therapy class. Is that right?
Right, and I also recommend you come back to verify.
Every 6 months? Right?
Yes.
Sure.
Because he has a habit of not reporting.
And of course, you could notify the court in that event. We could schedule a hearing and holding this in advance, right? These allegations.
I'm not
Yes,
holding,
sir.
yeah. Okay, go ahead.
I was just, if that's what,
Yeah.
what's the purpose of the moral recognition therapy class? What's that directed to achieve with the probationers?
It's to teach them moral standards, have a sense of ethics and values, as well as other life skills.
To what end? To keep them from reoffending, would you agree?
Yes, sir.
Be a good citizen.
Yes, sir.
Has he reoffended since he's been on probation, you know?
No, well, no, sir, he has not.
That's what.
I have no other questions concerning those allegations, Your Honor.
Thank you. So concerning those allegations, number 2 and number 3, I am going to find those true, that there's sufficient evidence to find counts 2 and 3 true. And so what, the ISF that he went to, it doesn't say if it was cognitive or, do you know, Mr.?
It would have been a combination of both at the time. It was substance abuse cognitive intervention tracks, because he tested positive for THC.
So he went, back then, you could do both. You can't do that now.
I
don't think.
confused on what they're offering at this point. But yes, he went for cognitive as well as substance abuse.
Okay.
And we're referring to the admin hearing from January 15th of 25, Your Honor.
Thank you.
Indicates that on January 12th of 2024, that it was recommended and approved that he, or on the 23rd, sorry, that he was successfully complete ISF cognitive and substance abuse tracks.
So was that a 6-month program or a 3-month program?
It is a 90-day program.
90 days, so it wasn't both stacked.
I think they changed what they offer now, but it's a substance abuse now, and then it's a cognitive, and then relapse at this time. They combined substance abuse and cognitive tracks.
Okay.
I think you wanted to address the court to your honor at the appropriate time. He has written a letter.
I've read the letter as well. Mr. Mays?
With the transcripts, I have them in my folder. When I went up to the GD, the workforce center, the lady said that she couldn't take them, so I started doing the GD on my own, like on my phone. When I get off work, I complete the classes on my own. I just never brought it to her attention, but I have been doing a different classes and stuff on my own.
Why didn't you bring it to her like you're supposed to?
No excuse.
Okay.
She just brought it to her.
Mr. Nichols?
Judge, I know that this is a tough call for the court. These aren't the worst allegations we've ever seen, but he's also in zero tolerance and has been several times sanctioned, both in jail and with the ISF programs. And still, after only 3 years on, not even 4 years on probation, Judge, we're back yet again. It's really a test of zero tolerance at this point, Judge, because that's what he was ordered, was no problems whatsoever. And missing 3 months of reporting is a pretty big red flag to me, Judge.
Let me look back at something real quick. Also, before I want to make sure everything is saying that it was burglary of a habitation, but at some point, it looks like, at least on the old PSI, it was attempted burglary of a habitation, a 3rd degree. I want to make sure all the administrative hearings, the motion to revoke, everything says burglary of a habitation. I want to get that cleared up.
Your Honor, actually, I think the indictment is attempted. At least I'm looking
Is
at the
it?
indictment that's captioned attempted burglary of habitation.
Okay, so the burglary of a habitation, do you want to make an oral motion to amend at least this motion that we're talking about today?
Yes, Your Honor, I will change burglary of habitation to attempted burglary of habitation, comma, a 3rd degree felony, Mr. Judge.
All right. So we're talking about a 3rd degree felony. So, Mr. Mays, the problem is that you just like to do what you want to do when you want to do it.
Yeah, Matt.
And-
Could I argue first? If you're, the thing I just wanted to say is, it's kind of glass half full, glass half empty thing. If you want to look at somebody that we're trying to return to the community as a productive citizen, which is the goal versus sending another person to the penitentiary, he has maintained employment. And he's had some, I guess, hiccups on probation as far as reporting, but he hasn't reoffended and he's employed. And it seems like he is making a positive contribution to society at this stage. I don't really see where the interest, me personally, as the interest of the community would be served is to send another person to the penitentiary where they are making enough progress. And again, it's marginal, but looking at the totality of the circumstances to keep working with him, to hopefully keep him out of prison where he can keep employed.
Well, here's my thoughts, Mr. Mays. You're not going home today. That's not happening. You're not going to walk out of here today. You're either going to get revoked to go to prison, or you're going to go to the cognitive track of ISF. Because somewhere along the path, you did not pay attention and you haven't learned from whatever treatment you've had before to make better decisions. You've been put on zero tolerance. You've been told don't miss another appointment. You have now 3 different times been given these opportunities and have not taken advantage of them. I don't disagree with Mr. Kimler. You haven't reoffended. You're not testing positive all the time. You're not doing those things, but you don't get to choose when you go to probation, when you don't, and you don't get to all of a sudden be really good at it when you have a court date coming up. Because that's something that is really frustrating to me, is that all of a sudden people start doing what they're supposed to be doing when they know they could go to prison. So, my thought, I mean, you think it's ridiculous. You have hardly any criminal history. You got into some trouble as a juvenile. You haven't been in much trouble at all. And you're not taking advantage of keeping this conviction off your record. And that's going to be on you, not on me, if this happens again. Because I have no doubt if I do what I'm thinking about doing and we're back in here again, Mr. Nichols is going to point out to me how many times I've given you an opportunity. Do you understand? There will not be another opportunity. I'm going to find that you entered your pleas of true to counts 1 and 4 freely and voluntarily. Find those counts true. Again, find that there was sufficient evidence to find counts 2 and 3 true and find those true. I'm going to find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to continue you on probation. I'm going to add an additional 3 years to your probation. So you could have already been done, but instead you have 3 more years. And that's the 1 year for every time that you've been an absconder. So that's what you're going to have to do at this point. I'm going to order that you enter and successfully complete the cognitive track of the ISF program. You need to take advantage of that program, learn to follow the rules, all the rules, get out, and you still have an excellent opportunity. But if you're back in front of me again, I'll see all of this. I'll probably wonder at the time what I was thinking today, but you will not get this opportunity again. Do you understand? 1 missed meeting. We're not going to do 2 or 3 missed meetings. We're not going to get to absconder status again. You miss a meeting, I want to hear about it in an administrative hearing. There's going to be a motion to revoke, and you're going to go to jail.
Your Honor, since she's going to cognitive track on ISF, could we rescind the moral recognition therapy? It seemed to be redundant.
Nope. Kind of seems like he needs some redundancy. Might help if he gets out and then has more to reinforce what he learns. So no, I'm not going to do that. All right, I'm handing you the trial court certification that shows this was not an agreement. You do have some rights to appeal. You can talk to Mr. Kimler about that. Good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.
Good morning. Are you Justin Chapa?
Yes, ma'am.
Mr. Chapa was previously in court, entered a plea of guilty to aggravated robbery. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, Your Honor, we have.
Any additions or corrections?
Judge, I'll go ahead. Judge, I received the addendum memo from the store manager concerning his thoughts on this. I think there must be some mistake there, Judge. I've seen no reports of additional robberies, no indication that he was a suspect in anything else.
Okay.
I understand his concerns and appreciate him giving his opinion, but I don't think that matches what the police reports and everything else indicates.
Okay.
As well as the gang affiliation, Judge. There's no history of any gang affiliation.
Okay.
I know of none, Judge. So it's concerning, I know, on its face, but after looking at it, I don't think it matches the evidence in this case, Judge.
Okay. What is this? So there's a misdemeanor driving while intoxicated, an MTRP.
I was going to ask the misdemeanor prosecutor to dispose of that as part of this deal, Your Honor.
Okay.
So he'd still be on his DWI probation.
Okay. Anything else?
No, Judge. My client was, I believe, actually employed at the time of this at Motiva, if you can imagine. Since then, he now works at his family roofing business. He's been doing great on that. I sent him to a professional counselor on his alcohol issues, and he's been in treatment for that and has done well and will do anything the probation department wants him to do on alcohol treatment. And I know it's hard to imagine, but this really just was a terrible drunk error in judgment that he made while highly intoxicated, and I do not believe we will have with treatment for his alcohol problems. We will not have any problems with him in the future. He is, other than what we saw in that incident, a very hardworking, respectful young man, and he is greatly sorry about what has happened.
All right. Anything else?
No, Your Honor.
All right, Mr. Chapa, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm not going to do that. I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 10 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. That is going to include that you enter and successfully complete the JCDI program, which is an intensive outpatient treatment program. As well, I am going to order that you wear a scram device, at least for some amount of time while you're on probation. That's a device that you put on that will tell me if you are drinking any alcohol. We'll get those updates on it. If it's tampered with, if it tests positive for alcohol, then that could be a reason for you to come back in on a motion to revoke your probation. I want you to get that scram device within 24 hours. So by tomorrow afternoon, you need to have that done. Mr. Crenshaw and your bondsman and actually probation can give you a list of places where you can get that scram device put on.
Judge, if I may, on the scram device, just because I tried to put one on a client 2 weeks ago, they not only require the court order, so we'll have to have a copy of that, but they only come to Beaumont once a week, and it's on Tuesdays.
Okay.
And I just don't think that we can make that happen today, so I'd ask that he at least have it
Tomorrow's
by-
Tuesday.
Well, I know, Judge, but we would have to get them the order and schedule the appointment, and it's a company that comes out of Houston, and they're very difficult to deal with.
Is that the only company that does it?
I would have to look into it, Judge. Are you talking about Recovery Hill?
Yes, that's who probation has sent my other clients to.
Yeah.
And they require all the paperwork, payment, everything to be done before they will schedule you for
Okay.
an appointment. I would just ask if we could please have until next Tuesday.
Okay.
To get that done.
All right, we'll do this by next Tuesday, end of business day. Should give you plenty of time to get that taken care of. So make sure Mr. Crenshaw obviously knows where to get that information. You need to make sure and get that done, get it paid for, wear it, and then not test positive. You cannot drink any alcohol at all, even though it's legal while you're on this probation. Do you understand? Also, a condition of your probation is that you are not allowed to be in possession of a firearm. That means on your person, it means in a vehicle, and it means wherever you're living. You cannot have any type of firearm. Do you understand that as well? Any other conditions?
I think that will cover it, Your Honor.
All right, then I'm going to hand you, well, first of all, Mr. Chapa, this is an excellent opportunity. And if you do everything that you're supposed to while you're on this probation, you do not have a conviction on your record. And at the end of the probation, if you are successful, the case gets dismissed. You're never a convicted felon. The other side of that, in this case, is extremely serious, because if you violate any condition of probation, you can be brought back into court, found guilty, so then you're a convicted felon, and go to prison for anywhere in the range of punishment, which is a minimum 5 years in prison, up to 99 years or the rest of your life in prison. Do you understand?
Yes.
All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation's going to call you up to her desk when she's ready to go over all of your paperwork. Good luck to you, sir. Good morning. Are you Jacob Graves?
Yes, ma'am.
And will your client waive the formal reading of the motion, Mr. Crenshaw?
Yes, sure.
Let me get that pulled up properly.
I think we're just proceeding on violation form.
Count one. Mr. Graves, in cause number 22-40761, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation April 10th of 2023 for the first-degree felony offense of arson, and that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count one alleges that you committed the new offense of driving while intoxicated October 20th of 2024. And is that true or not true?
True.
Did you enter your plea of true to count one freely and voluntarily?
Yes, ma'am.
And did you plead true to that count because it's actually true?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Crenshaw?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement is for you to plead guilty to that DWI with a 2-year probation on that down in misdemeanor court. And then your probation here would be modified to include an alcohol assessment and any treatment as required as a result of that assessment. Is that your understanding?
Yes, ma'am, it is.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Graves is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of true to count 1 freely and voluntarily. Find that count true. Find sufficient evidence to find you guilty and revoke your probation. However, I'm not going to do that. I'm going to continue you on probation. I am going to order that you submit to alcohol and drug screening. Any treatment that they say you need, whether you think you need it or not, you're going to be required to do that. Obviously, follow all of the rules and conditions of probation. This is a great opportunity because just based on that one allegation, you could be revoked and go into prison today. So I want to make sure you understand that you need to do everything you need to get your life on track, to not make these kinds of mistakes, be successful in the probation. Again, you still don't have that conviction, but it would be very different if you are back in here. Do you understand?
Yes, ma'am.
Probation's here. Is there anything else that you need to recommend or think that I should do?
No, ma'am, I was agree with the alcohol and assessment. We do have somebody in our office that does substance abuse assessments, but I know they found somebody else, which is perfectly fine as long as I'm updated.
Okay, sounds good. All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Are y'all going down there to take care of that misdemeanor today, or is that?
We're not, Judge, but at the next time it's set, I'm waiting to be paid.
Okay.
And next time it's set, it will be done.
Perfect.
We will plea and take the 2 years probation.
Okay, sounds good. All right, stay in touch with Mr. Crenshaw so you make sure and get that misdemeanor taken care of as well.
Yes, ma'am.
All right, you're free to go. Thank you, ma'am.
All right, thank you.
Good morning. Are you Matthew Baxter? And Mr. Baxter was previously in court and entered a plea of guilty to the first-degree felony offense of aggravated assault against a public servant. I've received that pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor. State has, Judge.
Are there any additions or corrections?
No, Your Honor. Not from the state, Judge.
So, based on obviously the nature of this offense and the looks like underlying issues with regard to drug issues and mental health issues, I am inclined, Officer Norsworthy has some very strong opinions, and I don't blame him for having those opinions. I don't know that there might be some type of upfront so they didn't do a full substance abuse assessment, just the when did you go to La Hacienda?
That was quite a few years ago when I was in my 20s.
Okay. And then you went to another place, Seacliff.
Yeah, I think maybe when I was around 23 to 25.
Okay, so this says that you have a medical marijuana card, but you're not using it. Is that correct?
That's correct.
When's the last time you used marijuana?
It's been months and months.
Okay, so what I'm going to do, Mr. Baxter, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you've made with the district attorney and defer all proceedings and place you on probation for 10 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. One of those conditions is going to be that you are not allowed to use any type of marijuana, medical or otherwise, without my specific permission. So if you test positive for marijuana, it's going to be a violation of your probation. There are other things you can do to get the help you need for any underlying issues that you have. You're going to be required to do a substance abuse assessment. And if that assessment says, you know what, SafeP is warranted, or ISF, or something outpatient, you will be required to do whatever it is that that assessment says. I want that assessment done. What's the quickest something like that can be taken care of?
Get it done within a week or two.
Okay, so you need to get that scheduled and within 2 weeks, so don't put it off. You have to go to the appointment and get it done, and then follow any recommendations of that assessment. And if you do everything that you're supposed to while you're on this probation, this is an excellent opportunity because you do not have a conviction on your record. And if you successfully complete the probation, the case will be dismissed and you'll never be a convicted felon. You have no criminal history. You have one I mean, this is it. This is your criminal history, is this case. And so there's every reason why you're getting this opportunity, but you need to understand, again, if you take advantage of it, it's great. At the end, the case gets dismissed. If you don't take advantage of this and you violate in any way, you can be back in court, found guilty of the offense, which gives you that felony conviction, and sentenced anywhere in the range of punishment, which is between minimum 5 years up to 99 years or the rest of your life in prison. Do you understand?
Yes.
I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up to her desk when she's ready to go over your paperwork. Thank you, sir. Thank you, Mr. Coleman. Let's see. Good morning. Are you Benjamin Barker?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
You will, Your Honor.
And I am going to take judicial notice of the court's file in 24-2194. May have already done this, but Mr. Barker was assessed for competency and initially found not competent to stand trial, was sent to the John Dunn Behavioral Science Center for Competency Restoration, received a packet April 1st of this year from them that stated that Mr. Barker had achieved competency. Is there any other issues with regard to competency?
No, Your Honor.
No, Judge.
Then I am going to find again that Mr. Barker is competent to stand trial at this time. And will he waive the formal reading of the indictment?
No, Your Honor.
Mr. Barker, the state's elected to proceed on the lesser included offense of the state jail felony attempted harassment of a public servant from October 8th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
You gotta speak up. Yes, ma'am.
And are you pleading guilty because you did what they charged you with? The attempted harassment of a public servant.
You gotta speak up.
You have to say yes or no so I can hear you, and also the court reporter can take everything down, okay? I have here on the computer some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Yes or no?
Yes.
And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Okay.
State attendance number 1.
No objection.
It's admitted. So it looks like the agreement is for that 1244 for 180 days.
And he has credit for 199.
But I think because it's a state jail, does he have to go?
What? Even if you punish it as a misdemeanor under 1244?
Because it's a state jail felony conviction. I'm not sure about that. Because he's been in jail, so he was booked in on it before. So they have a TRN, they have a thumbprint. If it's county jail time. Okay, I'm just going to do this. All right. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of attempted harassment of a public servant. Sentence you in accordance with your agreement to a term of 180 days in the Jefferson County Jail under Section 1244 of the Penal Code. It is my understanding that it's been verified that you have more than that amount of credit, and so you will receive credit on that sentence for all of that time as well. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I am also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a... Hey, let me read this out to you. I'm required to. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Parker about that. Probation is going to call you up to her desk when she's ready to talk to you, so don't leave the courtroom until you visit with her. Actually, no, she's not. I'm sorry. Never mind. You're done. Goodness.
Yeah.
To me. All right, you're good. You're free to go.
Thank you, Judge.
I do. I feel like it's been a long, too many words. Thank you. Yes, sir. Good morning, sir. Are you William Patterson? And Mr. Patterson was previously here in cause number 24-1270, entered a plea of guilty to driving while intoxicated, third or more. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
I have, Your Honor.
Are there any additions or corrections?
No, nothing to add, Your Honor.
All right, Mr. Patterson, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time follow the agreement that you made with the district attorney and find you guilty of driving while intoxicated. Sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections, but suspend that and place you on probation for 5 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. That is going to include entering and successfully completing the JCDI program. Also, you are required to serve 10 days upfront time. Let's see. So you're unemployed at this time, so there's no request, I guess, to do weekends if there's no job.
He's gonna go in and do the 10 days.
Okay, so you'll be ordered today to start those 10 days, and then as soon as you're finished with those, you'll get out of jail and go straight to probation, do what they tell you to do. If you do everything you're supposed to while you're on this probation, then this is an excellent opportunity because you'll serve that 10-year sentence while you're out on probation. The other side to that, though, is if you violate any condition of probation, you can be brought back into court and you could be facing that 10-year sentence that you've agreed to already. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Macon. You need to have a seat here in the courtroom. Probation's going to call you up to her desk when she's ready to go over your paperwork. Good luck to you, sir.
As soon as you finish your 10 days, call
And,
Wait,
Oh, I'm sorry,
Mr.
he's-
Patterson asked, can he do the 10 days starting tomorrow?
no.
I have nobody to pick the car up. I'm gonna pick it by myself.
We'll work on that.
Okay. Okay, yeah. Cause I had my granddaughter's gonna take care of me, so.
All right, the bailiff will get that stuff and let you make. Good morning, ma'am.
Good morning.
Would you please state your name for the record? I'm sorry, I can't.
Maria Morel Benavides.
And would you please raise your right hand? Do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English, so help you God? Thank you. Sir, are you Juan Torres Lopez?
¿Eres tú, Juan López? Yes.
And Mr. Lopez is charged with solicitation of prostitution in cause number 25-0211. And what is the announcement?
Yeah, we filed a plea rejection of 3 years deferred and a $500 fine.
Let me go. Sorry, hold on.
And that was explained to Mr. Torres in Spanish.
And Mr. Torres Lopez, I want to make sure you understand,
Quiero asegurarme que entiende usted
if you go to trial and you're found guilty,
que si vamos de
the range of punishment is between 6 months
si no pasa culpable puede ser hasta 6 meses.
and up to 2 years in a state jail prison. And I have a plea bargain rejection
Y enseñamos que no aceptó lo que
that has your signature with Mr. Kimmler's
tiene su firma,
that shows that the district attorney's office has offered, if you wanted to enter a plea of guilty,
que enseña que le dio enseña que se podía ser culpable o inocente.
a 3-year deferred probation,
Eran 3 años de libertad condicional,
$500 fine,
$500 de defensa
and you would be required to follow all of the rules of probation.
y tenían que estar requiriendo de seguir todas las reglas.
Do you understand?
¿Entendió eso?
Answer.
Diga sí.
Sí.
Yes.
You have every right to reject that offer and have your case set for trial.
Tiene el derecho de aceptar o no aceptar esa oferta.
I want to make sure you understand what your options are
Quiere asegurarse que entiende completamente cuáles son sus opciones
and what the possible consequences are if you go to trial.
y cuáles son las consecuencias si va a juicio.
And do you want to reject that offer and have your case set for trial?
Quiere retirarse con esta oferta y se enfrente de un jurado. Yes, Your Honor.
Is there any reason to believe that this offer would change?
No.
Mr. Torres, I want to make sure you understand
Quiero asegurarse que entiende
that after today, I will not accept this plea agreement.
que después de hoy no va a aceptar hacer cambios.
If you change your mind and want to enter a plea of guilty,
Si cambia usted su mente,
it would either be open to the court
va a estar totalmente abierto
or to some different plea agreement.
o algo totalmente diferente.
Do you understand?
¿Entiendes? Yes.
Okay, we'll set it on the trial docket,
Lo va a poner para que no lo pueda
and Mr. Kimler will begin preparation for trial.
decir. Solo
Thank you. Thank you, ma'am. Good morning, sir. Are you Timoteo Castaneda?
Yes, ma'am. Good morning.
And this is 250360. Mr. Castaneda is charged with indecency with a child by sexual contact. Mr. Crenshaw, what is the announcement?
This is our very first setting, Your Honor. Mr. Hoffbauer and I have been in discussions about a resolution. If we could please just have a standard reset.
Is there any issues, Mr. Hoffbauer?
Judge, that's correct. I spoke with Mr. Crenshaw about it. He's got, I think he's confirmed he has everything we need in regards to discovery. We're
Okay.
just discussing.
All right, so I'll just do a normal reset to give you some time to get with your client, go over all the discovery. Make sure you stay in touch with Mr. Crenshaw so you guys can visit, and maybe we'll get an announcement at that next court date. All right, thank you. And then you have Justin Chapa sentencing, Mr. Good morning, are you Cedric Fontenot?
Yes, ma'am. Sorry.
That's okay. And Mr. Fontenot is charged with solicitation of prostitution in cause number 241665. You all right?
Yeah.
What is the announcement?
Your Honor, I'd ask for 30 more days. I believe that will be a plea at that time.
Any issue, Mr. Hoffbauer?
No.
All right, we'll do a normal reset. Mr. Fontenot, make sure you stay in touch with Mr. Macon. He'll let you know when you need to be back and get your case taken care of. All right, you're free to go.
Tomorrow, call my office.
And then on Glenn Hicks,
Yeah.
Mr. Good morning, sir. And good morning, you're Eric Fornells?
Yes, ma'am.
And Mr. Fornells in 250267 is charged with injury to a child, elderly, or disabled individual. And what is the announcement?
Judge, I think this is our first announcement. Mr. Forno brought some paperwork with him this morning. He'd like to get to me. I'm asking for another recess so I can, or a recess so I can look at that.
State not apologies.
All right, so I'll just do a normal reset. Mr. Fornells, make sure you stay in touch and keep in touch with Mr. Rojas. He'll present whatever you have, discuss it with Mr. Coleman, and we'll see if we can get an announcement at the next court date. Thank you, sir. Mr. Parker, you have a sentencing on Gustavo Vasquez. Good morning, you're Anthony Vidal. And Mr. Vidal is charged with criminal mischief in 242062. And what is the announcement?
Judge, Mr. Waddell, we have been reset to verify the restitution, and Mr. Nichols he did talk to the complainant, so we can get all that straight. He's made a new offer to us that involves getting that restitution paid. Mr. Vidal, he's actually here with some representatives from Spindletop. We're going to be doing a conference call, like a team meeting, basically to see what he can afford, because all of his income comes through a
Right.
pay.
Okay,
And the restitution's about $3,000, Your Honor.
okay.
They just need to get that straight, see if it's something he can do.
Sure, so we'll just do normal reset to give you some time to see if that's something that can get taken care of. Mr. Vidal, make sure you stay in touch with Mr. Lewis so y'all can figure out how you'll go forward when we come back.
Thank you, Judge.
Thank you, you're free to go. Did you pick that shirt special for today? Do you even know what it says? Probably should have thought about that a little bit before you came to court, right? Oh, all right. You're Naquinda Ecclese, and Mr. Ecclese is charged with burglary of a habitation in 240478. And what is the announcement?
Judge, Mr. Ecclese, had recently had made bond again, and requalified. He was supposed to be hiring Mr. Kimmler, and he had been hospitalized for a few weeks. I think he was staying at the actual judge, and but he's gotten the money together where he's going to meet with him this Friday
Okay.
and take care of that.
All right, so you'll be able to hire Mr. Kindler this Friday? Okay, I'm going to reset your case, a normal reset, which is about 30 days. Until you hire Mr. Kimler, Mr. Lewis is your attorney. Stay in touch with him. If you get Mr. Kimler hired, he'll let us know, and then we'll go forward that way. Okay? All right, you're free to go. Pay attention to what you wear to court next time. Good morning, sir. You're Jimmy Hart?
Yes, ma'am.
And Mr. Hart, in cause number 250186, is charged with aggravated assault with a deadly weapon. And what is the announcement?
Now, we're asking for one more reset. I'm in discussion with the prosecutor about a couple things in the case that I need to make my client aware of some things that I've learned today.
Any issues, Mr. Nichols?
None that I'm aware of, Your Honor.
All right, so I'm going to reset your case about 30 days or so. Make sure you stay in touch with Mr. Parker and your bondsman. They'll let you know when you need to be back. You're free to go, sir. Lamira Henry, Mr. Parker? Or Lamira Henry?
Good morning.
Good morning. Miss Henry, don't wear tights or leggings to court next time. Okay, it's not appropriate. All right, this is 241668. Will your client waive the formal reading of the indictment?
Sure, Your Honor.
Ms. Henry, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from June 25th of 2024. Since you've made, going back to, how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you sign these, did you go over them with Mr. Parker?
Yes, I did.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated. You'd be on probation for 10 years. You would be ordered to pay a $500 fine and to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
Objection.
It's admitted. Is there any evidence that Ms. Henry is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. On your way out of the courtroom today, you need to stop and talk to probation, and she's at that desk right over there, okay? All right, we'll see you back at sentencing.
I've got it right here.
Aaron Roberts. All right, so are you Aaron Roberts?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Roberts, in 250250, you're charged with the state jail felony offense of theft of property from December 18th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they charged you with?
Yes.
I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Lane?
Yes.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 5-year probation. There wouldn't be a fine. There would be restitution ordered in the amount of $33,204. And the type of probation would be left up to me when we come back for sentencing. Is that your understanding?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Roberts is not competent?
No.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so we can get a pre-sentence report done. That'll give me more information about you, your case, any history, and we'll come back at a later date for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there. All right, we'll see y'all back at sentencing. You're Ronisha Chason?
Yes, ma'am.
And Ms. Chason has two cases, 24-2351 and 19-33107, a motion to revoke probation, and then a new case. And what is the announcement?
Your Honor, I've been talking to the district attorney. There's a co-defendant that may be somewhat culpable. And
That is the case, Judge. We brought this over from CDC. That's why it shows that the MTRP is so old. This is the allegation underlying that MTRP. It's my understanding we had some favorable discussions amongst us. That co-defendant was.
Judge Raquel West loses patience as the defendant pushes too far. Her stern warning makes it clear there will be no more chances, and the courtroom tension reaches its peak.